Uh, good afternoon, everyone. Welcome to today's talk. We'll be talking about police reports and basically what it means to file one in relation to a civil claim. Ordinarily, when we think about police reports, we think about them in terms of the criminal context, and that is normally the case. Normally, if you want to proceed with a criminal action against someone or a specific incident, then you file a police report. But you're not just limited to criminal actions, you can also do so for civil claims. And in essence, what we will discuss, we'll just give an overview of the nature of the police report, just some basic outlines of what it is, where you can make one, what does it necessarily lead to, or what is the effect of it. And then we will discuss it and run through it a little bit more in terms of the civil aspect as opposed to the criminal aspect. So very briefly, the police report, or how it is formally known as under the Criminal Procedure Code, is the first information report. And this is reflected in section 107, subsection 1, where essentially if there is information relating to a commission of an offense, then you go to a police station, you speak to the officer in charge, you can give an oral statement which will be put into writing. And then once that is done, you're required to sign that police report, and then that will be it. That will be your police report. You don't necessarily need to go to the police station and then orally say it. You can also prepare or pre-prepare a police report, and then you can go over to the police station and have that formally put into a police report. But it will still be subjected to the formalities of having it read over and also having it signed under the as per how it is under the Criminal Procedure Code. And essentially, what does that first information report mean, or what does it refer to? It refers to that initial information relating to the commission of an offense. So if you have a complaint, someone has done something and you think that it is something that is against the law, it is wrong, then you need to provide that first information to the police. And the police will then use that as the basis of the case to commence their investigation. So this is a judgment from a criminal case in Anwar Abdul Aziz. And this was in the High Court, and it pretty much spells this out. That is essentially the nature of what a first information report is. And where can you make one? You can make one pretty much anywhere. And this is reflected in section 107, subsection 3 and subsection 4. The purpose of this is really that if you have a particular complaint, you go to a police station, then that in itself will be deemed a first information report. That is what it is. It is just giving that first initial piece of information for the police to be able to act on. And you can give this to any police officer on duty anywhere in Malaysia. You may come across situations where someone may say, oh, you need to go to this police station, or you need to go to that police station. That used to be the case, I believe, pre-2006, but there were some amendments to the Criminal Procedure Code, and now the position of the law is that you can make one at any police station anywhere in Malaysia. You will find that now the reason why it may be you might think that, oh, it will be better to file this police report in this particular station instead of another station is purely for ease of convenience. So for example, something may happen to you in Negeri Sembilan, for example. You could under the letter of the law under the Criminal Procedure Code, file a report in Kuala Lumpur. And that will then be reflected as a formal police report. But the police officers in Kuala Lumpur will then have to transfer that file over to Negeri Sembilan for the Negeri Sembilan police officers to commence their investigations. So there is that administrative part there, and you will be pushed around back and forth. So that is something that you do have to bear in mind. You can make your police report anywhere, but just bear in mind that you may have to be pushed around depending on that particular administrative aspect of the investigation. And so the effect of the police report, I put this case here. This is a case from the Supreme Court of India, which I think pretty much represents the effect in as best as it can be, which is, and I quote here, the object of the FIR, First Information Report, from the point of view of the informant, is to set the criminal law in motion, and from the point of view of the investigating authorities, in this case the police, is to obtain information about that alleged criminal activity so as to be able to take suitable steps for tracing and bringing to book the guilty party. So in summary, what does that mean? It means that it begins the entire criminal investigation procedure. So it means that the moment that that police report is filed, the police officers are duty bound to investigate. But what that means will honestly depend on the circumstances of the case. So it may lead to criminal prosecution. It might be that that particular information and then the police investigating that complaint then says, hey, okay, there is enough here. I'm going to now transfer this investigation paper over to the Attorney General's chambers for the prosecution to determine whether they want to press charges or whether they want to direct the police officers to get more evidence, because it might be the case that, okay, there isn't enough evidence here to convict. So we will need more evidence. And this will depend, because essentially what you need to bear in mind is that in criminal law, there is a higher burden of proof as opposed to civil law. And that is why you can find these kind of situations here. Or the last one, which is the NFA, which is no further action. It might just be the case where, sorry, your complaint just didn't amount to enough information or enough evidence in order to lead for criminal prosecution. Who decides this? That's usually the prosecutor. The prosecution can direct the police to get more evidence. If the police says, oh, this is really it, this is all we have, then it might just be the case that the no further action just stays in place and you won't get criminal prosecutions. That's what it is in the criminal side. Now, how that does translate over, and I think this is just a preliminary point here, is that if, let's say, a prosecution does proceed against a person, now it doesn't mean that you are precluded from filing a civil claim, but your claim may be stayed or paused, stayed being the legal term. It will be paused until prosecutions are over. So essentially what that means is that if, let's say, you file a civil claim, and then in court, the court will be informed that, hey, there is a criminal proceeding that is currently ongoing against the defendant that you are now suing. The court may then have that discretion to stay the proceedings until the criminal proceedings are over. Now, this is the principle here is as explained in this case of MMC Engineering in the High Court, where if there are concurrent criminal or civil proceedings against the same defendant, meaning happening at the same time, in respect of the same subject matter, then the court has that discretion to stay the civil proceedings pending the conclusion. This is usually because of the defendant's right in the criminal proceedings, that it might just lead to some form of self-incrimination. Now, it doesn't necessarily mean that the defendant suddenly doesn't need to file a defense in a civil claim, for example. But in this kind of situation, the defendant is usually obliged to file an application to stay proceedings in the civil court, just in order to say, hey, I have a criminal proceeding against me, and I need this disposed of so that it does not self-incriminate, so that I do not produce any kind of evidence in the civil trial that may incriminate me in the criminal trial. Now, the court has that discretion to grant it or not. Normally, it is usually the case that the court will allow for such stays, and you will find that if there is that situation where these two proceedings are happening at the same time, the court will normally stay the civil proceeding in order to let the criminal proceedings proceed first. And then once that criminal proceedings is disposed of, whether favorable to the prosecution or leading to a not guilty verdict, then you can sort of proceed with that civil claim, and you can probably still establish your claim because there is that difference in that burden of proof. And also, I think this is very important, just to make sure that everyone knows this, that if you can be prosecuted for filing a false police report. This is found in section 182 of the Penal Code. And the sentence will, if you do file a false police report, then you would be liable to be punished with imprisonment of up to 6 months, or a fine of up to 2,000 ringgit, or to both. So now coming into the police report and then into civil claims. So we'll take into account, those are the basic preliminary points relating to police reports. And it mostly does operate within the realm of the criminal sphere, and it does affect how it plays out in the civil claim. But it doesn't necessarily mean that these things do not overlap or they do not relate. You can still file that civil claim, and then this is how the police reports usually play out here. So ultimately, what is the point of having a police report in a civil claim? It is evidence. And this is important if you want to establish this claim against another person. Even in a civil claim, you will need to establish that claim based on evidence. Now, the evidential value of this police report is explained in this case of Tan Cheng Kui in the year 1972. It is not a substantive piece of evidence, and it is inadmissible for the purpose of proving that the facts stated in it are correct. So this was taken from this old English case, and the quote here is that the first information is a document of great importance, and in practice, it is always and very rarely produced and proved in criminal trials, but it is not a piece of substantive evidence, and it can be used only as a previous statement admissible to corroborate or to contradict the author of it. Now, that is the same as how it plays out in the civil courts as well. It is a document that is evidence of the fact that there is a complaint against another person, that these facts that were have arisen and therefore had led to this police report. But it is not necessarily, it won't necessarily lead to the contents of it being saying as if it is true. Just because you have a police report doesn't mean the contents of it should be taken as automatic. The reason for this is because the contents of it are always the triable issues. They're always subject to the trial and to proof in the trial. So the court will then, in that trial process, will have to determine whether the facts actually did take place and whether there is a claim against another person. And that police report is merely there to just represent that these particular facts have arisen and have taken place. And I am now using this as a way to corroborate this particular situation. Now, the importance of this is that having documents in order to prove this claim is always helpful. And it is also worth bearing in mind that because you have that penalty for making that false police report, so it isn't something that you should be taking lightly. It isn't something which people file police reports for the sake of filing police reports. You do have people who do that, but uh, that shouldn't be the case. So the weight of that police report is already backed by that potential sanction that you may go to jail, you may get fined for filing that false one. So the fact that you have to put this in writing for a police officer with that threat of being sent to jail because if you made a false one, that in itself goes to show that this is something that is of some considerable weight, but it won't be uh, the main reason, or it won't be the main make or break situation for most cases. Now, you also find cases where if there is no police report, then that is fatal. In this case, we are looking at fraud cases, for example. So you will have cases where people who've entered into contracts, but then they have essentially, there are some fraudulent elements towards this contract. Now, in there have been a number of cases where the courts have determined that if there wasn't a police report that has been lodged in relation to this particular civil fraud, then these will be taken as only allegations. And you can see it in this particular case here of the case of Chong Wan Ping and Shamsuddin Haji Muhammad Yunus in the year 2009, where essentially the court here had assessed a list of cases which ultimately went to the same point, that in these particular cases that there were allegations of fraud and a police report was made. And so the court here determined that when you are dealing with allegations of fraud in a civil proceeding, then you need to lodge that report. And you can see it here in paragraph 11. The court is of the opinion that no police report or its equivalent was lodged. Therefore, the court is of the opinion that the claim by the plaintiff that the defendant had defrauded them must fail. So here, in these specific cases, the absence of the police report did end up being fatal. That if you are serious enough of this allegation that this person had defrauded you, and you have to file that police report, and not filing one will look very badly on you and may actually make you lose your case. And another thing is that these police reports can also help in situation where there might not be enough documentary or physical evidence. You may have witnesses, you may have oral testimony, and that's very, very good. That's helpful. But on the documentary side, that's lacking. And in these kind of situations, what the courts would deem this to be would be circumstantial evidence. Basically, evidence of the circumstances, which there can only be one real conclusion, which is that this particular thing must have happened. So these kind of evidence doesn't necessarily lead to direct proof that this person did this and this person did that. But if you were to just take it as a context as its whole, then it would lead to that conclusion that this particular wrongdoing did happen. And the reason why police reports can help in this kind of situation is that ordinarily the weight of that police report and the fact that it is backed by that sanction means that, okay, this is something that is serious enough that I was willing to face that risk of going to jail, and that I must put this in the police report. That in itself will carry some weight. And here in this case, Rajamani and Bank Development in the year 2015, the court here noted that when it comes to fraud cases and also when it comes to conspiracy cases, that the adduction of direct evidence is often difficult and it's not practically procured. So in this kind of situation, circumstantial evidence will suffice. And then you can see that there was another case here of Ku Teng Chai and Chakao Bajasa. Now, in this case, the Court of Appeal here had quoted a Indian decision, and this was in relation to conspiracy, where, and I think this quote here is quite indicative of why these police reports can be helpful for circumstantial evidence, that conspiracy as a whole is brought about in secrecy, and the proof of the same by adoption of direct evidence is really an impossible feat in most cases. And so that circumstantial evidence is usually taken in by process of inference or induction. So that point here, inference or induction to the relevant facts and the circumstances, means that you're not necessarily going to get direct evidence to prove fraud or conspiracy. But if you can take the evidence as a whole and the fact that a police report has been made, it may not have led to criminal prosecutions, but the fact that it has already been made and adduced into evidence, it will certainly assist the court in assessing the particular case and determining that based on the circumstances, a particular wrongdoing has happened, and that you are entitled to the damages that you may want if you are claiming for these kind of cause of actions. And you will also see that there are certain circumstances where it's not just an option, it is mandatory by written law that a police report needs to be filed in. So I use the example here of road traffic accidents. Because under the Road Transport Act of 1987 in section 52 sub 2, the moment that you have that accident, it says here, and I underlined it, the driver of each motor vehicle, a report of the accident at the nearest police station as soon as reasonably practicable, and in any case within 24 hours of such an occurrence. So if you go into an accident, you actually do have 24 hours to make that police report as soon as that accident happens. And that police report will allow the police to investigate that particular accident. But you will often find that it won't necessarily lead to a criminal prosecution under the offenses under the Road Transport Act. But that police report is certainly very, very important because it is mandatory. And if, let's say, you are in a road traffic accident, you have suffered some form of personal injury, and you are here to sue for negligence, then the fact that there is no police report as mandated under section 52 sub 2 would certainly work against you. So here we can see that this is not a criminal issue. This is a civil issue. It's a civil claim of negligence, but yet that police report is valid. So just to conclude, and just to give that summary, that the production of a police report, there will be a presumption that the police report exists, and you don't need to call the maker, so you don't need to call the police officer who you made that statement in front. It will automatically be presumed that this is a valid police report, and it is something which you can already take at face value. But the contents of that police report, that will still be subject to proof, and that is the purpose of the trial of that particular subject matter. And then you will find that it is an important piece of documentary evidence, but only where it is relevant. So I've shown you in some of the cases where in fraud and conspiracy cases, that is relevant. In road traffic accidents, that is relevant. It's not relevant for everything. So for example, it won't necessarily be relevant in a friendly loan arrangement. If, for example, you borrowed money off a friend under a friendly loan arrangement and you want that money back, filing a police report is not necessarily going to win you your case. And it is in those kind of situations, it's not necessarily relevant, and it's normally not an ideal situation or an ideal thing to do. And then you will find that it's normally a prerequisite for pseudo-criminal civil claims, or where written law mandates the filing one. So pseudo-criminal civil claims, so claims like fraud, conspiracy, written law like the Road Transport Act. It can also be relevant in cases like contempt of court, which can arise even out of civil claims. So that's not necessarily a criminal or direct criminal action. You can find that a police report may be very helpful in those kind of situations, those kind of cases. It shouldn't be taken lightly, because that punishment for filing that fake police report is heavy, because you're looking at your time, you're looking at a fine, that will go on your permanent record. And if you take this police report into evidence, into court, and you swear by that, and it later transpires that it was a false police report, then that could also lead to further actions under perjury. So a police report isn't something to be taken lightly. There are huge consequences from filing a fake one. And the last one, it shows that the case is tribal, that there is an issue here that has led to a person making this genuine complaint, that it was serious enough that this person needed to risk those sanctions in order to file this police report. And this might help even at the pre-trial litigation stages, where, for example, you might have a case where the facts may be there, or but the documents or the proof may be lacking. And this might subject you to applications like striking out or summary judgment. So the fact that you're willing to face the issues relating to filing that police report shows that, okay, there is here a genuine complaint. But it won't necessarily mean that, it's a surefire way to win you your trial. It is a surefire way to survive a strikeout or a summary judgment application. But it is the weight attached to it is relevant enough that a judge will have to think twice before reaching a specific conclusion that may go against you. And that's pretty much all I had to share. And I'll be happy to take some questions. And I see that there are a few questions that have already been put into the chat. Okay, so I'll be happy to take them. So the first question from Farzana Rizwan. Hello there. For the tort or conspiracy to injure, is a police report essential to prove the claim? So you have situations, for example, now two types of torts or conspiracy, of lawful and unlawful conspiracy. And it's not necessarily essential, but it doesn't harm your chances if you do file in a police report. And especially if it is something relating to an unlawful conspiracy to injure, because the fact that there is that element of unlawfulness means that this is something which may even have some form of criminal elements to it. So it won't prove your claim, but it will certainly help substantiate and back up the claim that you are making. And then the next one is, what is the effect of omission or errors in the police report? What are the effects of subsequent amendments? The effect and omission of errors. Now, in a police report, if those errors are made in an honest manner, so it is just something because and at the end of the day, we're all human and we do make errors. And that won't necessarily lead to prosecution. And you can still file a police report to clarify or to amend or to say that this is something that I want to put on record again to assist in curing that particular error. But if there are still errors in your police report and you do not take steps to try and correct that, then that could actually lead to the reversal, where if you go to trial and you say, I filed a police report, but then under cross-examination, you find that you contradict your police report, because of the errors, because of the problems that have arisen, then suddenly the weight of that police report has gone against you, and it may show that your claim won't necessarily be successful in that situation. Okay, and then I see that there are some questions. There's some questions on Facebook as well, and there's this case here, and this person here, Mila Vieri, Virginia. If a lawyer prepares the draft police report to a client and they lodge it starting with salinan daripada pihak pengadu will have any adverse effect to the client. It won't have an adverse effect in the sense that, or rather, let me just answer this question this way, that ultimately, if a lawyer is drafting that police report, it is always usually based on facts that your client has given or the client has given, and that you're trying to address it in a way that is most accurate. But that is still first and foremost the complaint made by your client. So when they go to a police station, they make that police report, it is still in their name, and it's still a position that they will have to take. However, of course, the lawyer must also be very careful to not make mistakes, or not to mislead, or not to put anything incorrect or inaccurate into a police report, because ultimately that may also be problematic for the client. So always take care when you do that police report, and make sure that when a police report is being drafted by lawyers, it's always helpful to have good, sufficient information, but it doesn't necessarily have to be everything. It doesn't necessarily have to be equivalent to a statement of claim, for example. It doesn't have to be that wordy. It just needs to be very brief and enough key points of information for the police to then take the next steps to investigate it. And whether that leads into criminal prosecutions or to an NFA, then that is wholly up to the police. Police reports needed in all pseudo-criminal cases. Are there any special circumstances of pseudo-criminal cases where police report is not necessary? In fraud cases, at least from the fraud cases that I've seen, having a police report is usually a must. But in all the other cases that I've listed, for example, conspiracy, you don't necessarily need to have a police report in a conspiracy case, but it really doesn't hurt your chances. Ultimately, what you need to be able to show to the court is enough proof to establish your claim. And a police report does help in that. Okay, client lodged police report, and result is RTM proceeded the claim in civil court and obtained a court declaration that the defendant defrauded plaintiff. How do we need to enforce such declaration to police for their further action on defendant's criminal liability? So as I understand it, the civil court had granted that relief, that granted that declaration that the defendant was defrauded, that the defendant defrauded the plaintiff. That will mean that you can then proceed to execution and under the civil procedure. So you can go to execution, you can claim damages, go for assessment of damages. It won't necessarily mean that I have a court order that says that this guy defrauded me and therefore I'm now pushing it to the police, because ultimately it goes back to that whole burden and standard of proof. That the burden and standard of proof here is different for a civil claim, it's different for a criminal claim. In a criminal action, it is beyond reasonable doubt. That is the terminology, and that means that it is something that really, really must be almost close to confirm that this guy is guilty. But a civil claim is not like that. A civil claim is on a balance of probability. It means uh, it's like if you're weighing it up with a 50-50 kind of situation, but the 50-50 sort of tilts one way or the other. That is what we mean by balance of probabilities. So there you see the burden standard of proof is different. It is lower at the civil level. So because it's lower at the civil level, it won't necessarily lead to further criminal prosecution or further criminal actions. However, if the prosecution does think that a particular case is worthy of further criminal investigation and further criminal action, then that is something that the AGC will take on board, and then they will deal with that. But for the purposes of a civil claim, if you already have an order that says that there is a declaration, and then you are entitled to the prayers that you did get, then you can proceed with execution through the normal. Okay, I think that's all we have for today. Thank you very much for joining me, and thank you very much for your questions. I think this was a very engaging topic, and if you have any other further questions, please feel free to give us a call, or you can just email me, and these are my details here. Thank you very much for joining in. Take care, stay safe, and I'll see you soon.